Does the defendant intend on putting on a case any witnesses or testifying?
We plan on doing our Rule 20, Your Honor, and no.
Okay, go ahead with your Rule 20.
Can we do that when we get back from lunch?
Sure. If you're telling me you don't plan on testifying or you don't plan on calling witnesses, let's finalize the jury instructions though right now. Did you get a chance to look at those?
We did.
All right. Let me go to the state first. Why don't we do it this way? We'll just go through one page at a time to make sure everyone's on the same page. So the cover page, then page 2 is duty of the court, evidence to be considered, rulings of the court. Those are standard. Any objections to those from the state? Defense?
No.
Page 3, direct and circumstantial evidence, redacted exhibits, indictment not evidence, self-represented defendant. Any objection to those from the state?
No, Your Honor.
From the defense?
No. No.
Sorry, okay. Page 4, comments are not evidence. That was modified a little bit because the defendant represents herself. Credibility of witnesses, testimony of law enforcement officers, expert witnesses. Any objection to those from the state?
No.
Defense?
No objection.
Page 5, defendant need not produce evidence, defendant need not testify, voluntariness of defendant's statements, and then the start of the jury not to consider penalty. Again, all standard. Any objections from the state?
Judge, we actually have no statements by the defendant, so
That's true. We could probably delete that. There were, yeah, I think that's right. There were no statements, so I would intend on deleting that. Anything else from the state?
No, Your Honor.
How about from the defense?
No, we agree.
You agreed that that should be deleted?
Correct.
Okay. Page 6, presumption of innocence, burden of proof, evidence of any kind, voluntary act. Any objection to those from the state?
No.
Defense?
No objection.
Page 7, the absence of other participant, motive, and then the charged offense starts with the charged offense and then defines what is first-degree premeditated murder. Any objections from the state?
No.
From the defense?
No objection.
All right, page 8, a definition of premeditation. Then we have the elements of conspiracy, scope of proof of conspiracy, and proof of membership in a conspiracy. Any objection to those from the state?
No.
Defense?
No objection.
Page 9, definitions, intentionally, knowingly. A part of the accomplice. Any objection to those from the state?
No.
Defense?
No objection.
Then top of page 10, accomplice, act, and I don't know why aggravated assault
think
in there. I
that's-
must have left that in from the last one. I'm going to delete aggravated assault. I think that was on the crime prevention from our last trial, so my mistake on having that in there. I'll delete that. Other than that, any objections from the state?
No.
Defense?
No objection.
And then we have the jury foreperson and the closing instruction. Any objection to those?
No.
Defense?
No objection.
And then we have a form of verdict. Any objection to that from the state?
No.
Defense?
Oh, I'm sorry.
No objection to it.
All right. Any others that I haven't included that the state has requested?
No, Your Honor.
Defense?
Your Honor, we would ask for mere presence just because they put up the videos of me being at the storage unit at that time.
Well, mere presence would apply to this crime scene itself.
I understand that, but
would
I think
think.
it would cover it.
I don't think it's applicable, but I don't mind including it if the state agrees with the state's.
Given it's the conspiracy to be safe, I'm fine including it in there,
We'll add
Judge.
mere presence back. I think I had it last time. I will probably put that. How about if I put that right behind absence of other participant before motive? In that area, it makes sense, I think.
That's fine.
All right, any other additions?
That's
All right,
it,
so
Your
when
Honor.
we come back from lunch at 1:20, the defendant will do her Rule 20 motion. When this when the jury comes back in, I'll turn to the defendant who is telling me she's going to rest her case at that time, and I'll read the instructions, go right into closing arguments. All right, thank you. All right, we're back on the record. State of Arizona versus Daybell, Sierra 2022-001242. The parties are present. Ms. Daybell, go ahead.
With the Rule 20, Your Honor?
Yeah.
Okay. The court must enter a judgment of acquittal on any offense charged in an indictment if there is no substantial evidence to support a conviction. Conspiracy to commit first-degree murder requires the state prove that I, one, agreed with another, in this case Alex, that one or more of us would engage in conduct that equaled first-degree murder, and two, that I intended to promote or assist in the conduct. The only evidence that has been presented simply establishes that I have been seen on video placing items into a storage unit. A phone that is connected to me through an email made phone calls during this time frame, and a Google search relating to Gilbert, Arizona. None of this evidence establishes that I agreed with Alex Cox to engage in conduct that equals first degree. The state has the burden of establishing all elements of an offense have been committed, and thus there is not substantial evidence to support a conviction.
All right. Does the state want to respond for the record?
Chair, looking at the evidence in the light most favorable to the state, there is substantial evidence for a jury to find the defendant guilty of conspiring with Alex Cox to commit first-degree murder of Brandon Boudreaux. In this case, in determining if a conspiracy existed, the jury can look at the fact that the defendant went with Alex Cox to buy the burner phone, that she loaned her Jeep to him to be used, that she rented a storage unit, that she Googled how to remove the rear seat, that she hid the tire and seat, and that she created an alibi for her brother by having those two phones interact while he was in Gilbert, Arizona.
All right. The standard is whether a reasonable juror could find the defendant guilty, whether there's substantial evidence that a reasonable juror could find the defendant guilty. The state has presented a compelling case that Alex Cox traveled to Gilbert, Arizona, and attempted to kill Mr. Boudreaux. There's other circumstantial evidence that establishes that the defendant was aware of Mr. Cox's plans and facilitated those plans and assisted in those plans in several different ways. It's ordered denying the motion for Rule 20. Anything else? All right, just confirming that the defendant doesn't intend on testifying or calling any witnesses?
Correct. I would like to again just admit the letter from Tammy. It was marked.
Did we get
Just
it
wanted to
marked?
let you know that.
Okay, 203, for purposes of maintaining the record and any appeal issues, 203 would be admitted for the record, but not to the jury. Anything else? All right, let's bring the jurors in. I'll turn to the defendant when the jury's sat, and the defendant presumably will say that she rests as well. Thank you. All right, thank you. The jury is now present. Everyone can be seated. The defense has rested before lunch. I'll now turn to the state rested before lunch. I'll now turn to the defense.
The defense also rests, Your Honor.
All right, at this time, we are going to hand out the final jury instructions. My assistant will hand those to the jurors. Do the parties already have their copies? Yes. Okay. All right, it looks like all jurors have copies of the final jury instructions. Much like the preliminary instructions, you're free to follow along or just listen. I'm going to read these instructions as required. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You as jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Admission of evidence in court is governed by rules of law. I've applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you in determining the facts. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and the defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant. The defendant's decision not to produce evidence is not evidence of guilt. Before you may convict the defendant of the charged crime, you must find that the state has proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. The crime of conspiracy to commit first-degree murder requires proof, 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of the other participants until it is established that a conspiracy existed and that person was one of its members. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means bodily movement. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of the jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. Make sure every member of the jury is present during the discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. In just a few minutes, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have any question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with the parties before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about the case until I accept your verdict. 12 of you must agree on a verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows. There is no significance to the order in which the options of guilty and not guilty are listed on the verdict form. At the back, this is the sample verdict form. You'll get an official verdict form from the clerk. But this is the sample verdict. Count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Vallow Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about October 2nd, 2019, as follows. Check only one, and the options are not guilty or guilty.